Okay, well, hello everybody. Thanks for joining us. There might be other people that join us as we get going, but I wanted to welcome you to our CondoWise learning series. This is number 4. And today we're going to be talking about enforcement in condominiums and the Condominium Authority Tribunal. My name is Patricia Aaliyah. I'm from Aaliyah Associates. Today we have with us Victor E. and Julia White, who are going to help me explore this topic with you. We will take questions at the end. We're going to give you a little bit of an update on the pandemic, which is always a current topic for us, and we would recommend that you take a look at our COVID-19 bulletins, which are on the website as a resource. I wanted to mention to you as well that on Wednesday, the Golden Horseshoe chapter of CCI is going to have a lockdown lowdown on the pandemic if you want further information and detail. And that CCI Huronia is having a webinar on Friday about maintenance and repair because it still has to go on. So with that said, we're going to jump right into it and we'll advance to the next slide, please, Zainab. We are recording this, so if you would like to share this with your team members, please, we would encourage you to do so. Julia, please go ahead.
Okay, so we're going to start the session off today with an update on the pandemic and just where we are today. So as many of you are likely aware, the Ontario government has introduced a new tiered or zoned system that classifies which restrictions will apply based on current case numbers and modeling. Each public health unit will then be placed in a zone, or has already been placed in a zone, and the government can then move that public health unit into a new zone with more or fewer restrictions based on the data. Municipalities can then impose more restrictions where the same are deemed necessary, and then condos can impose further restrictions based on what makes sense or is deemed necessary for the community. So the zones, as they appear on the slide there, are green, yellow, orange, red, and gray, with red being the most strict aside from the lockdown, and gray being a complete lockdown. So we encourage you to take a look at the Ontario government website for more information on the restrictions under each zone, as I'm sure many of you have already done, as well as our website for updated articles on COVID-19 restrictions. So the Ontario government also has a section on its website where you can see an overview of COVID-19 cases, including active cases and recovered cases, the number of individuals who are in the hospital and in ICU, and where the cases are actually coming from. You can search the cases by area, which is interesting if you want to see what the cases are like specific to the area where your condo is located, as opposed to the surrounding areas. This could be helpful when you're making decisions with respect to amenities, visitors, AGMs, board meetings, and so on. We will be posting a short article on this soon with a number of useful links for you. So please check our website for this information, and we'll also be posting an e-blast about it. So as of November 23rd, 2020, both Peel and Toronto were moved into the gray lockdown zone until at least December 21st. This means essentially reverting back to stage 1 where we were in March. Trips outside the home should only be for essential services and purposes. No indoor organized public events or social gatherings, except for those from the same household. This also means for condos, amenities must be closed. Construction projects and repair and maintenance work that's deemed essential can continue with proper health protocols in place, but any elective renovations or construction work should not continue. We've also gotten a number of inquiries regarding whether non-essential visitors should be permitted into the condos. We understand that it's impractical to ban all visitors to the corporation. However, condo boards should consider whether a ban of non-essential visitors is necessary or desirable. Reducing the number of visitors who attend at the corporation will obviously help to reduce the potential for transmission of the virus. So condos do have the right to make policies that govern the community, and therefore may wish to develop a visitor protocol, which would require that all visitors identify themselves upon entry to the common elements, identifying themselves as essential or non-essential, identifying the purpose of their visit, and then going through the screening protocol that the condo has in place. If you don't have one in place, you should put one in place. Screening should include filling out a COVID-19 questionnaire and temperature taking. With the colder months approaching, condos must be diligent and continue to manage the risks. Policies and procedures are important, and if not already, should be implemented by boards, specifically with respect to the use of amenities, cleaning protocols, visitors, and so on. There's also a question about collection and storage of information and data provided by guests and residents, and how condos should be managing this. If not already, condos should contact legal counsel to draft and implement an information management and privacy policy. Also, condos should consider what will happen in the event that a resident tests positive for COVID-19, or in the event that a unit owner dies in their unit. So do you have the necessary contact information to deal with these situations? Condos should be requesting up-to-date information from all of its owners and residents, including who to contact in the event of injury, illness, or death, the names and information for regular essential visitors such as caregivers, and so on. Boards and property managers should also be thoughtful about the fact that gathering sizes will likely be decreased for the foreseeable future. This means condos should make it a priority to pass an electronic voting and meeting bylaw and come up with a plan to hold their meetings, especially AGMs, in the future. So under Ontario Regulation 54120, under the Condo Act, this regulation has authorized an extension to the temporary suspension period, which allows condos to hold their AGMs virtually without a bylaw in place until May 31st, 2021. However, we still recommend that corporations adopt a bylaw allowing virtual meetings and electronic voting. This was discussed in our previous CondoWise session regarding AGMs. While the ability to hold a virtual AGM without a bylaw in place will be permitted until at least May 31st, the deadline to actually hold the meeting itself does not change. So AGMs must still be held within 6 months of the fiscal year end. Okay, Zainab, next slide, please. So we're going to shift our focus now to the CAT. So the Condominium Authority Tribunal is an online tribunal dedicated to resolving and deciding condominium-related disputes in Ontario. The CAT has developed an online dispute resolution system to help people resolve their disputes. The goals are convenience, efficiency, and affordability. Condominiums are statutory creatures created under and pursuant to the Condominium Act, and the CAT is an administrative tribunal that is governed by the Act. So throughout the next hour, we're going to take a look at the enforcement process under the CAT. And first, we're just going to turn things over to Victor to do a quick overview of what the CAT is and what has changed since October 1st, 2020.
Sure, thanks, Julia. So as I'm sure many of you might be aware, as of October 1st, 2020, the CAT has basically expanded its jurisdiction to include what we call PVPS issues. That's parking, vehicles, pets, and storage. So anything to do with those 4 issues, including how to indemnify or charge back the unit owner for the condo's legal fees and cleanup fees, for example, that's also going to be part of the CAT's new jurisdiction. So we haven't seen the first wave of cases yet. They're still making their way through the system. But so every condo board member and every manager should be aware now that if, for example, a unit owner has a dispute with regards to pets, vehicles, parking, storage, or chargebacks regarding those 4 issues, that can now be taken to the CAT. On top of that is still the existing jurisdiction of the condos tribunals about records requests. So records and PVPS issues are now all within the CAT system. That also applies to condos. If you want to enforce a parking, pets, vehicles, or storage issue, or if you want to get clarity about whether your indemnity clause can allow you to charge back for those 4 issues, you have to, as a condo, apply to the CAT for an enforcement order basically now. You can no longer go to the Superior Court. You have to go to the CAT for those 4 issues. Again, that's pets and other animals, vehicles, parking and storage, and the indemnity or chargebacks for those 4 issues. So that's something that the condo boards and managers should be aware of, but also in terms of if you come across one of those issues. So for example, if a unit owner is caught letting his dog defecate all over the common elements, the condo board now has to consider, when they charge back for that damage, they have to consider the possibility that that unit owner might go to the CAT to fight the condo on that. And that's part of a larger cost benefit analysis that I think we can talk about later. but it is definitely something that the condo boards and managers should be aware of because it is now a possibility. So I think Patricia is going to talk about the expansion and the reason behind this expansion of jurisdiction. Patricia?
Thanks, Victor. Next slide, please, Zainab. So why expand into the CAT? Well, it's pretty clear that the courts, while some courts have an understanding of condominium over time has really evolved into a specialized space. And courts do not have the time or the specialized knowledge to deal with condominium matters. And the courts are very busy. So it's, the logical kind of progression. Administrative tribunals are an integral part of the administration of justice and has been confirmed by members of the Supreme Court of Canada as being important elements in providing justice to societies such as the Canadian Society. The CAT has been created as a specialized administrative tribunal. Administrative tribunals, as I have said, are part of the rule of law framework. And condominiums are everywhere in Ontario. And thus, the number of disputes is also on the rise. When you have that many people together, it's inevitable. But should it not be cost effective and efficient? So each condominium is a unique proposition based on location, design, and constating documents. An administrative tribunal that focuses on this type of knowledge is going to be able to address more effectively and in a focused way the issues within a condominium. Creating a specialized space for alternative dispute resolution also makes tremendous amount of sense. If you've followed Aaliyah Associates for the many years that we've been in existence, you know that we've always been active proponents of alternative dispute resolution. We think that it's good if the parties can control the resolution of their disputes, because in a condo, you don't walk away. You get to see each other down the hall, or you get to, bump into your property manager when you're able to actually be in contact. So isn't it better if you could resolve the disputes more internally and with respect to the community? Expansion from records to PVPS is a continuation of this plan, as Victor has mentioned. So we are on the move to expanding the scope. So I'm going to turn it back over to Victor to talk about scope and power. Victor?
Sure. So as I mentioned earlier, the condo, for example, if they come across a rule violation regarding pets, vehicles, parking, or storage, they have to now go to the CAT to enforce. So as I'm sure you're aware, under Section 119 of the Condo Act, not only do unit owners and tenants have to comply with the Act, but so do condominium corporations. And one of the duties under the Act is that the condo has to enforce its declaration, bylaws, and rules, and any violations of the Act as well. So there is a competing duty between the condo's legal obligation to enforce and the condo's cost-benefit analysis that they'll have to do now for those 4 PVPS kind of issues. So under the new expanded jurisdiction of the CAT, you have to go to the CAT, but at the same time, going to the CAT will cause a, first of all, it's an online tribunal. So whoever's doing it, for example, the manager, the board member, or the condo's lawyer, has to be available basically 24/7, because the CAT is a 24/7 system, and it's an online system, and you could do it from your couch while watching TV, but that is something that is now that you have to keep in mind as a board member if you want to take it on, or as a manager if you want to take it on. If you are the representative for the CAT, it is quite onerous on a day-to-day basis, just because there's so much going on. You get an email every single time something changes. And the timelines in the CAT, especially in stage 3 adjudication, are pretty short from what I find. So, well, first of all, because I'm sure I think there's a couple slides later that talk about the timeline and the process, but it's because the CAT has an actual timeline in place of how long they want these litigation pieces to go on for. Whereas in Superior Court or even in small claims court, there isn't that kind of timeline pressure. So, again, if you have a CAT issue, so for example, you see a guy parking his large vehicle that's too big for the parking space, and your declaration of rules say that every vehicle has to fit within the boundaries of that parking space. If you're a condo and you want to enforce that now, you can no longer go to Superior Court, you have to go to the CAT. And at the same time, an owner, for example, if they see their neighbor with a giant pickup truck that is, for example, obstructing their access to their parking space, they can actually take that owner directly to the CAT now. So it can be an owner versus an owner. And in the rules of the CAT system, they also make the owner who's taking the other owner to the CAT at least give notice of the case to the condo corporation. So it could theoretically be a three-way, three-party kind of litigation piece now in the CAT that's completely online. So if you're a manager or a board member, it's important to keep track of basically if you get an email or a letter from the CAT that's called a notice of case inviting you to join a CAT file, you have to make sure that you do respond, you do log in, and you do basically join the case to see what's going on. Because that form letter, it's just a one-page invitation. It won't set out what the dispute is about, or even who all the parties are. They'll set out the case name with some of the parties' names, but it might not tell you what's actually going on. And so it's extremely important for everybody to be vigilant. Watch your mailboxes, both physical and email, to make sure that you don't miss a notice of case, because we're getting lots of condos now that are coming to us now saying we didn't get a notice of case until way later when we got a phone call from the CAT because there was a last-ditch effort by the CAT to notify the condo. So please make sure you keep on top of your mailboxes, because again, it might not just be the condo commencing an application against the unit owner or even an owner against the condo. It might be an owner versus an owner who then loops in the condo that way.
Victor, do you know if it's only paper notice that the CAT sends, or is it electronic?
They do both usually. So sometimes if, for example, they can do it by email, they'll do it by email. But what I find sometimes is that the managers have moved on. So the manager's email was the email that they had, or the unit owner gave the CAT, and then it's a personal email, for example, to that person's inbox at that company. The person's now moved on from that company, and nobody's monitoring that inbox. So in those situations, sometimes the CAT will send a physical one-page letter to the condo's address, and sometimes during the stage 3 adjudication, they'll have somebody call the condo at whatever phone number they can get to see if the condo is aware of the CAT application. So it really is, they are putting the onus on you guys to check your emails and check your mailboxes, because if you miss that notice, that litigation piece might move forward without you or your input and just be based on what the unit owner is saying about the condo. And that's not always great. So sometimes, to be honest, it's a little too late for us to come in and save you guys. So if you can, please, again, stay on top of your mailboxes. It is extremely important, especially with an online tribunal, to watch your spam filters, watch your email inboxes.
So Victor, do you think it's a good idea for condos to perhaps have a dedicated email address for the condo?
Yeah, so we always try to encourage the condo to have both a management email. So for example, whatever TSCC so-and-so management at hotmail or gmail.com, but also a board email. So that the board of directors themselves, if something falls between the cracks, as we know, managers are very busy. They manage multiple sites a lot of times. So if you have a board email, that actually is another way the CAT can try and get in contact with you guys. And sometimes it is actually, to be honest, in our experience, the board that catches this and then notifies the manager to stay on top of it, basically.
Great. Thanks, Victor.
If you go to the next slide, I think Patricia might talk about the process, or I can.
I think it's Julia, actually.
Oh, sure. Thanks.
Go for it, Julia.
Okay, so the CAT uses a 3-stage process. Stage 1 is negotiation, where the users will work together to try and resolve the dispute. So it could be owner to owner or condo and owner. Stage 2 is mediation. If the users can't resolve the dispute between one another in stage 1, they'll work with a CAT mediator who can assist them in finding a resolution. Stage 3 is the tribunal decision. So if the users can't resolve the dispute in stage 2 through mediation, the CAT will hold an online hearing, and then we'll make a determination after listening to all the evidence. All stages of the CAT take place online, so the tribunal is very pandemic friendly. After stage 3, if necessary, you'll have the ability to appeal the member's decision if you think there's been an error with respect to a question of law. So there are 2 options in this regard. One would be filing an appeal with the divisional court, and 2 would be filing an application for judicial review. Both of these options are complicated, time-consuming, and costly, and it is advised to seek help from your legal counsel before proceeding. Victor, is there anything else you'd like to add?
Yeah, so I mentioned before, it's important, this graphic is a little tough to see here, but it's on the CAT website where basically they have stipulated timelines, and they do try and follow these pretty strictly to basically get this over with within a few months. Unlike Superior Court and unlike in the small claims court, which sometimes those litigations can take years, this is meant to be over within less than half a year. And so you do have to, again, stay on top of things because those deadlines in the middle, so for example, in stage 3, you have a deadline to write a statement or provide evidence, those are sometimes only 3 or 4 days long. So unless you get an extension from that individual CAT member, you are on a very tight timeline. And this will go to the whole need to have adequate and sufficient records available for you guys to just take to the CAT as evidence. So it's important because a lot of times what we see nowadays is that the CAT gives you a 5-day deadline. The managers are now scrambling to try and put everything together when really it should have been, already in the condo's records to exist with beforehand. So it's extremely important, and I'm sure Patricia will get into this, about record keeping, especially with the whole smorgasbord of different issues that will come before the CAT with parking, pets, vehicles, and storage.
Yeah, and I think, Victor, your point is well taken in terms of the timeline being condensed. It's also condensed because it's 24/7. So courts don't operate 24/7, and there's a reason for that. So I think, more pressure is put on the participants in the process in that shorter time frame. So yes, a shorter time frame is a great idea. And I think it helps, end the dispute quickly, but you have to realize you're on time and or your time is being demanded outside of usual business hours. So we could have the next slide, please. I'm going to talk about the goals of enforcement. And, really the CAT is, relying on us as condos and the directors to do their job and enforce the rule of law. But that really begins in the condo. The objective is to ensure that rights are protected. Owners, mortgagee, the condominium corporation, and we are held to that duty. We have an obligation under the Act to ensure compliance, as Victor has talked about. We cannot ignore that just because we transfer to a different structure or system. Justice definitely should be impartial and transparent, and that's one of the key things that we should be looking to the CAT for, because they are taking on a judicial type of function, and they're different than the courts. Conflicts of interest. I just recently took a course at Osgood about certification in administrative tribunal work. And one of the interesting things there are these adjudicators that were on this panel really talked about, you have to be aware of the conflicts of interest and how to recognize them. And they're not just talking about the parties. They were talking about the administrative tribunals themselves and trying to find a balance. Administrative tribunals, as I've said, are an integral part of society and affect access to justice. But they also are the methods through which policy from government is also going to be reflected, which is very different than a court. Both courts and administrative tribunals are not perfect systems. You could find the flaws in both. And the point is to work both of them together so that at the end of the day, people have effective access to justice, not at a high cost, sensible decisions that are based in the parameters of the rule of law, which means procedural fairness, transparency, compliance with the actual case law. And, we have to recognize that the CAT does not have the same judicial independence that the courts do. So this is going to be an interesting time as to how it sets its framework. There are a lot of tribunals out there that about, the HRTO being one of the most predominant. And they too have had an evolution. Every tribunal in its organic stages is going to have an evolution and finding boundaries, but they always want to be seen as administering effective law. And that's what I think all of us are here to help contribute to. And condominiums have their part to do. As a fourth level of government, there is definitely a requirement for a corporate governance structure. So if we could go to the next slide. We're going to talk a little bit about evidence now and how that fits into that goal of enforcement in the fourth level. So Julia, did you want to start us off?
Yeah, so we're just going to start with what is evidence. In this context, evidence is essentially anything that is used to prove or disprove a violation. In condominiums, evidence is usually complaints from neighbors, security reports, photos, surveillance video footage, incident logs, a signed agreement, or anything else, again, that helps prove or disprove a violation. Evidence generally also includes written correspondence from management and compliance letters from the corporation's solicitor, if you've gone that far. As well, evidence can include advice and opinions from experts. This could be an engineering report or a legal opinion from the corporation's solicitor. So in this sense, the board should seek legal advice where necessary and rely in good faith on a written opinion from legal counsel in order to satisfy their due diligence obligations under the Act and ensure that they're exercising the care and diligence of a reasonably prudent person. Board members are not expected to know the answer to everything and should seek help where necessary, especially if you think the issue will be contested or be put in front of a judge or a member of the CAT for review. So this will help paper the trail, so to speak, and show that the board took steps to educate themselves and make an informed decision. As a board member, when you're unaware, unsure, or where there's a big decision to be made, you're better off speaking to counsel. Condos are statutory creatures, so the value of getting a legal opinion is to get a third-party perspective by someone who's trained in the law that gives insight on the risks and how to manage those risks. It can also clarify expectations for other board members, for management and for owners, and help set parameters. So boards should be trying to identify the risks and troubleshoot certain situations. You want to be as proactive as you can and manage claims and risks before they arise, instead of dealing with them after the fact. Directors aren't paid to know the law like lawyers are, and there's more to the law than just the Condominium Act. There's many different statutes that intersect. So not seeking legal advice in the interest of saving costs could actually be more costly in the long run. So moving to why evidence is important. Evidence is the most important factor in convincing the decision maker at the CAT. It's critical in being able to effectively enforce against a unit owner or a resident. At the CAT, the condo's representative will be required to present its case, and this will need to be based on facts and evidence. It's the only way to show that what you're alleging or trying to prove is in fact true. So at the hearing stage, the parties will have the opportunity to present their evidence and make arguments to support their position in the dispute before a CAT member, who will then make a legally binding order. The goal is to show a clear violation of the corporation's governing documents or to dispute and appropriate and relevant evidence which proves or supports the violation. So Victor, can you take us through how you use evidence at the CAT?
Sure. Before I do that, Patricia, can you perhaps enlighten our audience about perhaps good corporate governance practices before we move to the CAT? Because I think that's really important to have in place already to help proactively almost anticipate these CAT claims coming forward.
Sure, Victor. I think, this might be a good place to drop that in. I'm a big fan of corporate governance and policies and procedures. Now, the first thing I'm going to say is don't have policies and procedures if you're not willing to enforce it, because if it's shown that you don't enforce it, that's bad evidence. We want good evidence. So policies and procedures help set a discipline, and I'm a big fan of discipline, around how we get through our statutory standards, really. Because from board to board, manager to manager, there's often not always the legacy that we want. We do want to see, though, legacy and consistent standards of enforcement, but we also just don't want to see a path of enforcement. We want to see that it was developed against a set of benchmarks. Like, for example, if you have security working in your condominium, do you have a process and a policy around recording incidents, and that the manager has to be reported to on a regular basis of all incidents? My expectation and my understanding from many of the multi-stories that we work with, that yes, they do have a procedure, they do have team meetings, and they have follow-ups on events and incidents that happen in the condo. And then those are also brought to the board as part of the board package to determine what enforcement or compliance steps need to go forward. In that as well, you would also have part of your information management policy, because if there is video surveillance, as Victor has also mentioned and Julie has mentioned, we can actually figure out how we're going to use that. We recently had a client that was required to provide information about a unit owner on a criminal investigation. Now, fortunately, we were able to guide the corporation through that and help them implement a good management policy around that information disclosure. But there were certain thresholds that had to be met. Do they have a warrant? Does the police, do they have the right to ask for that information? And on what authority are we releasing it? And do we have to let anybody else know that we released it? So, you know, there is a real value, instead of being caught in the middle of a moment where you have to make a decision quickly. Wouldn't it be better to know what the process was around you to make sure that you hit all the benchmarks? And the other thing is too, when you develop policy, the question is also, are you asking the right questions and collecting the right information? Are you using information appropriately? Under PPADA, you know that we need to manage personal information, and that covers use, collection, and disclosure of information. So as much as the Condominium Act sets a really good benchmark under Section 55 on how we can use information, more is required, because we are collecting, especially in the pandemic, a lot of information. For example, the information coming in from your supplier that somebody in their team has COVID and has been in touch with your members of your community. How are you going to address that? Are you actually getting back accurate or adequate information from the supplier so that you can, in the condos context, manage the risk better? So do you also have a way for sorting evidence and information and protecting the same? How long are you going to keep certain records in the context of a CAT application? And, you know, this is the thing. There's value in collecting information concurrently to the event. Why? Because it's still fresh in the minds of the people involved. So how many people are you collecting that recollection from? Because everybody has their own version of the truth. Why? Is the truth that different? Well, it can be, depending on the perspective you're collecting it from. So taking concurrent statements from people, doing the proper investigation at the right time, having a protocol and procedure around doing that for certain types of issues can be valuable to a corporation in the long run. And Victor, you're going to expand now on how that value comes to fruition.
Sure. So maybe on a concrete, more practical level here, maybe the first starting basis I should probably mention is that everything in the CAT is electronic. So I know before we would have physical evidence, for example, you know, written statements signed by people that we produce as originals so that the signature can be verified. That kind of stuff is what we call physical or first-hand evidence. Now with the tribunal though, and because again, it's a tribunal, not a court system, the rules of evidence are more relaxed. And because it's an online tribunal, everything has to be somehow converted into an electronic format. So for us, with records at least, most of the time it's just a PDF. So scanning in the record, scanning in the records request, scanning in the board's response to that records request, that was fairly easy. Now, however, with the expansion, it's the PVPS issues, the parking, pets of vehicles, and storage issues that will be very, very, I guess, require a higher threshold of record keeping because, as Patricia mentioned, let's just say, for example, a video file. If you have a surveillance system, not every surveillance system is geared to just export a simple MP4 or an easy to read video file. Some of the security systems require a specialized reader to view this security footage. So in order for us to be able to present that evidence, so for example, you caught the guy on camera letting his dog defecate on the common elements, you want to provide that video evidence to the CAT, you have to make sure that your video system, your viewing system, can export that file into an easy to read video file. The workaround, and it's not a great workaround, is I've seen some managers just hold up a cell phone to record their screen at the concierge desk or the management desk to then have that as a video file uploaded to the CAT. And sometimes that's not the best kind of evidence because it is a little more grainy. It's not firsthand evidence, so then we have to say who recorded it, whose phone was used, when did they do so, and all that stuff instead of just the firsthand evidence of the surveillance footage. So unfortunately, with the CAT expansion, the threshold and the requirements of evidence gathering are a lot higher. And it's going to be a lot, it's going to be interesting to see how different condos manage that, because it is, again, an evidence-based tribunal at the end of the day, even if it is online and the rules of evidence are more relaxed. And maybe the last part on the slide I should mention is that what we're seeing a lot now is that a lot of managers and a lot of board members are doing the stage 1 and the stage 2 themselves. So they're doing the negotiation. So that's the stage where you directly negotiate with the other party. And then stage 2, mediation, where you are still negotiating, but there's a CAT mediator that's assigned to your case to try and help the parties resolve it. In those 2 stages, what we're seeing a lot of is that the managers and the board members are doing that themselves. And then when they can't resolve it, when it goes to stage 3, adjudication, they then give it to us. And then by the time they transfer the file over to us, the stage 2 has automatically closed. So when the CAT actually assigns a stage 3 adjudicator, the system actually moves from stage 2 into stage 3 automatically. And when you're in stage 3, you can no longer access stage 2. So a lot of what I find is that when I'm retained at the 3rd stage, I try and ask the managers and the board members, please don't transfer it to me ASAP so that I can go in and preserve the stage 2 records. So for example, the messages and the evidence uploaded, or if you can, please do that yourselves before you hand it over to me. Because a lot of times what I see is that even though technically speaking, stage 2 and stage 3 are supposed to be separate stages, a lot of self-represented unit owners are still talking about what happened in stage 2 inside stage 3. And it would be very helpful for me, and I'm sure most condo litigators, to know what actually happened in stage 2 so we can respond appropriately. And just even for our sense of getting a bearing of where this dispute is at, it would be very helpful to have a stage 2 record of what went on. So in terms of evidence, not only do you have to worry about it on the front end, so for example, again, making sure that your electronic evidence is all in order, but also when the actual application is going on, that you are also keeping a good record or a good compilation of the evidence and the messages exchanged in stage 2 before you hand it off to your lawyer in stage 3. I'm going to also talk about the next slide, which is basically one of the big questions we get a lot is, can the condo recover the legal fees from the unit owner who's brought a claim against them in the CAT? So even if, for example, the unit owner brings a frivolous claim to the CAT and says, okay, let's just say, for example, now, my next door neighbor is parking a gigantic pickup truck inside his parking unit, and therefore I want to get a penalty of some sort against the condo or against my neighboring unit owner. Let's just say that at stage 3, the adjudicator from the CAT says, no, that's not correct. Let's just say the guy's pickup truck is actually within the boundaries of the unit space. In that situation, even though the condo spent all this money on defending itself against this application, and even though the condo essentially was found not guilty, if we can use that language in the civil context here, if they're found not liable for any damages whatsoever and not liable at all, can the condo then charge back or actually ask the CAT for a legal costs award? So on the question of legal cost awards, it is very, very rare for a CAT to actually award a condo their legal costs, because there's a rule in the CAT's rules of practice that actually say the default presumption is that nobody gets their legal fees back. Now, what about an indemnity clause? So a lot of condos in their declaration, ideally, have a pretty broadly worded indemnity clause that says, for example, the unit owner, if they cause any losses, costs, or damage incurred by the corporation due to the owner's breach of the Act, Declaration, Bylaws, or rules, then the condo can charge back those fees and those costs to the unit owner's common expenses. Now, the question is, and we haven't seen the answer just yet, is whether that kind of indemnity clause in a condo's declaration will override or provide an exception to that default presumption by the CAT that no legal fees will be awarded. So for example, if, for example, you do go to the CAT to enforce a no defecation by pets on the common elements rule, and you say, look, CAT, we have them on camera, we have the DNA test of the dog's poop coming back to us, and it is that owner, can we now charge back, and can we now charge back the legal fees even for bringing the CAT application in the first place? Now before, yes, you could, in the Superior Court, before the CAT's expansion, you could get 100% of your legal fees back. Now we have yet to see whether the CAT will follow suit and whether that indemnity clause in the declaration will actually provide that reason for the CAT to sort of set aside, I guess, the default presumption that they have. Now, not every indemnity clause is worded the same. Every condo usually has quite a different indemnity clause based on, generally speaking, how old the condo is. So newer condos, generally speaking, have a very broad and nicely worded indemnity clause. The older condos, and the older you get, the worse it gets, either don't have one at all or have one that won't apply to the specific situation. So it's very, very, very important before you charge back now for any PVPS issues that you double check your declaration to make sure that you can actually charge back that cost. Because if you can't, you're going to get taken to the CAT, and the CAT will then ding you guys basically for trying to charge back something that you could not legally charge back. And essentially, there's a case out there that everyone's talking about. It's called Amlani. And basically, that Amlani case was where the Superior Court recently said the indemnity clause, the wording of the indemnity clause is so important, because if you cannot actually charge back under the indemnity, then everything is out the window. Your lien, your notice of lien, all your chargebacks of your legal fees that you thought you could get are now out the window. You can't actually get them back. So it's extremely important to check your declaration and then talk to your condo's lawyer if you want to look into amending that declaration to hopefully get a broader worded or a more modern worded kind of indemnity clause to anticipate these CAT costs that might be coming forward. And I think Patricia will now go on to the CAT's pros and cons.
Yes. Thank you, Victor and Zainab. So are there pros to the CAT? Yes, I think there clearly are. Disputes are going to be resolved by the parties, and it's really an integral part of the process. And it'll be nice to get off everybody's table the very straightforward type kind of disputes that we see. Specialized knowledge is also a bonus, I think, when you see really good administrative tribunals that are well versed on the client, which here is the condominium. When they know this, it's easier for advocates and for parties to explain even the issue. Lower standards of evidence. I think sometimes people believe that it's hard to gather good evidence. I'm not always convinced of that. I think it's more on the proactive side of the corporation to collect good evidence. And lower standards of evidence can make it easier, but you're also going to have to challenge those more as to whether or not those are adequate standards of evidence. Access to a quick resolution any day. That's a great thing, I think, and it's positive change. Self-help remedies, again, knowledge is power, and the CAO is doing a lot of good work on developing information brochures for people that are starting right at the buying stage of buying a condo to living in a condo. There's also a deep and rich body of case law that has been developed over many, many decades by a lot of the lawyers that you've come to know across Ontario. And the good thing is that body of case law is still the law. Nobody is going to be reinventing and making up laws. That is still the body of law that will be relied on. And many issues have been litigated so that people understand the thresholds to be proven. Self-represented litigants can be heard, and so there is access to justice. And I think that's important when we look at unit owners who are, for example, denied the records or the list of unit owners. How many times have we seen cases like that, which I've always thought are a waste of people's time? So next slide, please, Zeta. With respect to the cons, costs are not awarded for investing in compliance. And I think this is a real sticking point for me. It is going to discourage compliance, and I'm going to say, please don't be discouraged. Go for compliance, because you are going to set the parameters for the parameters of your community and how it operates. There may be exposure to oppression claims, depending on how matters are evolve in an event, and that is a Superior Court issue. It goes only to Superior Court under 135. There are risks that we're going to contract out of the Act, and so we really need very well-versed people that understand the Condominium Act so that solutions are not contracting out. I'm concerned about the inherent bias against obtaining legal representation at the beginning, because of the fact that costs are not awarded. Now, this is a real problem. And I understand where it may have been rooted in because of some of the types of litigation that have occurred. But I can honestly say that certain litigation, especially some of the big cases that we dealt with at our firm, often are started by other parties and the corporation is just defending. Can you imagine having to have all the unit owners eat their own costs on an action that they never started, which was absolutely not in any way the corporation's fault? I would turn your attention to the Senate case, which Anthony Caslanovo of our firm carried through to the end. And I could not believe the number of turns and twists in that case, and everybody had to defend. And you know, the costs were enormous, but at the same time they were driven by the unit owner. Unrepresented litigants may also increase costs, and this is a concern for me, that people are dissuaded from getting litigation counsel, but at the same time litigators know the law and they can be actually very effective at narrowing issues. I've seen it on mediations that have been handled by our firm, and they actually end up saving costs. And owners pay twice. They pay twice in the sense that, you know, they are now going to also bear the legal costs when they didn't do something wrong. That's not right. And that was never what consumer protection legislation was about. The ability under 134.5 to be able to obtain an award that covers the cost was always to hold accountable the party who had actually made the mistake or had intentionally breached. It may not even have been a mistake. So, you know, this is the thing. When you go into a condo, you know what the parameters are, you know what you're buying into, and you're expected to comply. So let's go to the next slide. And so we at Lee Associates, we really like solutions. We don't like to just sit in the negativity. So we want to ensure that the spirit of the Act is preserved as consumer protection legislation, encourage enforcement for sure. We want to ensure that rules of evidence are consistent to allow the most relevant and reliable evidence to substantiate rulings and ensure that the case law is followed. Why? Because those were actually, you know, court processes where the test was done. It was developed by judges who are impartial. There is no public policy necessarily driving them, and there's no other administrative component that drives the policies that may impact decisions. Ensure that costs do not escalate because of a lack of advocates. I think this is important. I think advocates actually can reduce costs because they know exactly what the law is. Ensure that disputes have clear and consistent outcomes and are resolved quickly. This can only be to the benefit of society as a whole, condominiums as a whole, unit owners, boards of directors. Ensure that the CAT works within a reasonable budget. Absolutely. Who pays for the CAT? Who pays for the CAO? All unit owners. And I say that not as a condo lawyer, but as a unit owner. And I think really strongly award legal costs to parties who attend and prove their case. I do not see why, if something does not resolve at stage 1 or 2 of the CAT process, which are cost-effective levels, and it has to go to the final stage, I think that costs should be awarded because people have invested in compliance, and there will be somebody who will be seen not to have complied with their obligation under 119. So if we can move to the next slide, please. So as we look ahead, our advice to you is amend your declarations to be clear. Make sure your indemnities are fulsome as to the one that Victor has talked about. Create clear and reasonable bylaws, create clear rules, and you know, my plug is get those policies and procedures in place if you're willing to actually enforce them. Next slide, please. And please enforce. This is really critical. We cannot have, you know, fourth levels of government work if there's no enforcement of the laws. So now at this time, I'm not sure if you have any questions that you want to put into our chat box. We will do our best to answer those for you. We have a few minutes today. We didn't run out of time. But if not, and you come up with a question afterwards, please feel free to let us know, email us, and one of us will get back to you.
So maybe Patricia, in the meantime, I can offer some commentary. I guess number one, in that Senate case, and I'm sure Anthony will be very quick to harp on this, even though it was a lot of legal costs, he did win and recover those legal costs because essentially we forced the sale of the condo unit. So the condo was out a lot of money up front, but eventually it did recover. The second thing is, of course, with the CAT's expansion of jurisdiction, it is going to be very tempting and going to be very, very appealing on a cost-benefit analysis for the immediate board and the immediate manager to just look the other way and not enforce against a dog defecating on the common elements. But I think, as a person who lives in condos myself, it is going to then set a precedent for somebody to say, look, I clearly had my dog pooping in the common elements on camera, in front of a camera, in the elevator even, and nobody enforced against me. And as somebody who lives in a condo with lots of dog poop and piss sometimes in the elevators, that is not a good precedent to set. And again, it really comes down to the CAT has to eventually award legal costs so that condos are no longer scared of trying to go after enforcing compliance here.
Well, yeah, and I think that's the thing, right? So it's like penny wise, pound foolish, because it sets a precedent. And we've seen cases where the courts have said, well, you acquiesced. You didn't do anything. You let them keep dogs for 10 years and then decided to enforce against a poor cat owner. Well, too bad. You sat on your laurels. And so it actually can go to the detriment of creating that kind of pattern. So I think there isn't a value moving forward to enforce and show a history of doing it consistently. There are questions now in the chat box. I'll read them out, and this one, Victor, might be yours because you have some expertise in this too. Is there a way to change the declaration if you never will be able to get 90% of the unit owners in a room to approve, either in person or by proxy?
Sure. So there are essentially two ways to change a declaration. One is that 90% or sometimes 80% threshold, where you have to get the unit owners to consent to basically the declaration amendment. And I'll come back to that and why I use the word consent instead of vote. The second way is, of course, through the court application to Superior Court. But unfortunately, that wording in the Condo Act for that kind of route is very limited. It's limited to essentially if there was an error or an omission in the declaration as drafted by your developer. If there was no such error in the drafting of it, it's very hard to prove to the Superior Court judge that this declaration amendment should go through the judicial route of just having a judge who is not elected, who is not part of your community, just order the declaration amendment. The first route of the 80% to the 90%. Now, I know a lot of people say, well, we can't get 80 or 90% of people to even show up to a meeting. Under that section of the Act, it actually is not a vote at a meeting. It's actually a meeting just to talk about the declaration amendment. And then the condo over several months and even years can slowly acquire the written consents of each owner to get to that 80 to 90% threshold. So what we see sometimes is some condos will spend several months just talking to every single owner and getting those written consents signed by each owner to hit that 80 or 90% threshold. So that's actually one of the ways we try and encourage encourage condos to talk to the owners. And you might as well get to know everybody anyway. I know in some large condos, of course, that is going to be physically impossible. But again, it's all about the ground game. It's all about knocking on doors, and maybe not in COVID, but at least talking to people over the phone or by email or through your building portals or Facebook or whatever, and getting those consents over a longer period of time.
Yeah. And there's another question. Why would the notice not say who are the parties involved?
So the notice of case that you guys get from the CAT is a very, very it's a very standard letter that will basically set out the name of the case. So for example, if it's John Doe versus TSCC 1234, that's all you'll see. It'll be the style of cause, what we call a style of cause, sets out the party that's litigating versus the party that's offending. And so sometimes if it's a three-way application, for example, it will not set out all the parties. It will just set out the first person who brought the case and then the first defendant who was defending against the case. So for example, again, if a unit owner has a neighbor who's parking a giant pickup truck in his parking space and the unit owner wants to bring his neighbor to the CAT, it'll actually just say John Doe, so the guy who's complaining, versus Bob Smith, the guy with the pickup truck. And it won't say the condo corporation, even though the condo corporation is legally entitled and has to actually receive a notice of case. So when you get a notice of case, even though your condo corporation might not be named as a party in that notice of case, you should still look into it because it could affect your condo. For example, if they're fighting about the validity of that rule, the condo has an interest in actually defending the validity of that rule because that rule applies to all of the owners, not just those two. So that's why the condo actually is entitled to receive the notice because they might have an interest in defending it. The notice of cases that I've seen are right now just for records requests. So I don't know whether the CAT is thinking about updating the notice of case and maybe making it easier to read or more accessible to people. But I've seen too many managers and board members just ignore it because it's too much wording, it's too much, what yada, 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 and they think that it'll go away if they just don't respond. That's not the case. It will still go on even if you don't participate. And sometimes that's worse.
Yeah, I agree. As the CAT is now covering parking and storage, would somebody leaving items in their parking spot in their garage now be covered by the CAT? Yeah, I think clearly that is where it's going to go now in terms of storage issues. You would want to make sure you brought your application there.
Yeah, so it's not only parking spaces, but also locker units. So I think that's why there's PVPS, it's pets, vehicles, parking, and storage. So storage will cover both parking units, even your locker units, and we have yet to see this, but even perhaps your dwelling unit. For example, if you are storing a combustible material on your balcony.
Oh, okay, yeah.
So it actually might cover that as well. So again, if you are a condo, you will have to enforce, if, for example, a guy has a propane tank or propane barbecue on his balcony and the rules say no combustible items, you will have to go to the CAT to enforce. And basically, again, that's something that the condo board and the managers really have to look at as a possibility.
Mm-hmm. Well, with that, I want to thank everybody for being with us on our CondoWise learning series for 2020. This is our last one for the year. We will be coming back in January with a variety of different topics in the context of the CAT and the pandemic and a lot of other things. You can always reach out to us and send us an email if you have questions on the topics covered in CondoWise. They are posted to our website during the week that we present, so you can share them. And what I wanted to do at this time is, on behalf of all of us at Aaliyah Associates, I first wanted to wish you happy holidays and thank you for everything that you've all done to support your condominiums in a variety of ways. We have a variety of people on our calls who are in service of condominiums, directors, unit owners, and managers often. So I wanted to thank you. This has been a very interesting year for all of us, and we appreciate working with many of you. And it's been a real learning experience. So stay kind, stay healthy. All the best to you and your families for the upcoming year. And we'll see you then. Take care. Bye-bye.